Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to this week's episode of Winning Isn't Easy. Before we get started, the Florida Bar says I have to give you a legal disclaimer that says this podcast isn't legal advice. Nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Do you have ME/CFS or fibromyalgia? Now, I talk a lot about ME/CFS and fibromyalgia claims because I think that they are the trickiest cases to win. In this episode, I'm going to talk about three topics. But I want you to understand that even though I'm talking about ME/CFS, it doesn't mean that these topics aren't relevant to other diseases because disability carriers will generally play out of the same playbook. Topic 1, is a diagnosis of fibromyalgia sufficient to overcome an Aetna disability insurance claim denial? 2, chronic fatigue syndrome disability insurance claims and what you need to know about limited disability benefit clauses. And fibromyalgia and objective medical evidence. Hartford challenges a 20-year claim. Ready to take a break before we jump into this week's episode? Let's do it. Welcome back to Winning Isn't Easy. Chronic fatigue syndrome disability insurance claims and what you need to know about limited disability benefit clauses. Did you know that many disability policies or plans have subjective medical conditions or limited disability benefit clauses? That means that your payment of disability benefits can be limited to just 24 months. And there is often a fight, in my view, about the terms of these limited disability clauses and whether a particular medical condition falls within the limited disability clause. So let me tell you the story about Tucker versus Express Scripts. This is a case out of Missouri. Tucker was covered under a disability plan that had a limited disability benefit provision that limited the payment of disability benefits after 24 months for certain medical conditions, including chronic fatigue syndrome. Now, when there's such a policy limitation, there are two arguments that we make as attorneys to try to rebut the application of this clause. The first is that the policy limitation is so poorly written that we can't figure out whether this condition is included or not, and or the disabling condition isn't one of the limited listed benefit conditions. Now, in Tucker's case, the benefits for chronic fatigue syndrome were limited to just 24 months. It's right there in black and white in the terms of the policy, or rather the plan. Now, the disability plan found that Tucker was disabled by chronic fatigue syndrome and denied his claim for the payment of benefits that was greater than 24 months. And of course, his case ended up in federal court. So what did Tucker argue? He argued that, hey, I'm not disabled by chronic fatigue. I'm disabled by post-viral chronic fatigue syndrome, fibromyalgia, and chronic Epstein-Barr infections. So that's another approach. Another approach to attack these limited disability clauses is to argue that you're disabled based on medical conditions that aren't listed in the limited disability insurance clause. But I'll tell you, that can be tricky for several reasons. Now, first and foremost, many of these policies or plans have what's called a discretionary clause. That's a get-out-of-jail-free card. The discretionary clause basically says to the judge, you've got to defer to our interpretation of the terms of limited disability benefits, and judge, you can only overturn that if the interpretation is unreasonable. Secondly, you need to understand that the judge is going to review the carrier's medical analysis and conclusions about what medical conditions are the cause of the disability and whether or not those medical conditions are excluded by the limited disability benefit clause. So in Tucker's case, he's saying, look, my disabling diseases are post-viral chronic fatigue syndrome, fibromyalgia, and chronic Epstein-Barr virus. And Epstein-Barr is not one of those limited benefit conditions, so voila, you got to pay me. Now, in this case, the plan had determined he was disabled because of his chronic pain and fatigue and not the chronic EB infection. Tucker's physicians and the plan's physicians actually relied on the same medical article in trying to come to a conclusion about the relationship between CFS and Epstein-Barr. And guess what? Treating physician had one opinion, the carrier's physicians had another opinion. They didn't agree. One of the fundamentals under the ERISA case law is that a carrier plan doesn't have to accept the opinions of the treating physician over that of its own doctor. In other words, there is no treating physician rule. And when you have an abusive discretion clause, the courts will routinely say that it's not an abuse of discretion for the carrier to accept the opinions of its own doctors, even if they're liar for hires, and their own interpretations of the medical literature over that of the treating physicians. So as a result, in this case, there was a claims denial, and the court upheld the claims denial. Regardless of the approach that you potentially take, either arguing that the limitation is poorly written or the disabling condition isn't one of the listed conditions, the bottom line is that you've got the burden of proof, particularly when you've got this arbitrary and capricious standard of review. Look, disability carriers are in the business of denying claims, but I don't think you should necessarily give up. I do think that there is hope, but you have to have a very strategic approach to not only filing the claim, but to filing an appeal and filing ultimately your complaint if needed in federal court. Got it? All right, let's take a quick break.